Hello and welcome to the Husch Blackwell Labor Law Insider Podcast. I'm Tom Godar, your host, and I'm glad that you've come along. In this podcast, we welcome guests with practical expertise and experience regarding labor law issues, and they share their insights related to this ever-changing area. The breadth of developments in laws related to unions and individual workers' rights that we are experiencing under the Biden-appointed National Labor Relations Board and led by General Counsel Jennifer Abruzzo is unprecedented. These developments demand that employers and those giving counsel to organizations stay tuned into these changes and make necessary adjustments to their practices and to policies. When President Biden was elected, he promised to have the most union-friendly administration ever, and he is fulfilling that pledge. So buckle up and hang on for this wild and wonderful ride in the world of labor law. And welcome once again to the Labor Law Insider. We're going to discuss remedies once again. This is part 2 of our discussion. I hope you've had a chance to listen to part 1. And we're joined by Terry Potter, Megan McManus, and Tricia Moore as our Labor Law Insiders. It's a delight to have them. Terry works with Husch Blackwell's St. Louis office, and before that was a board attorney. Megan McManus was the HR director for a union organization, so she brings both inside counsel experience as well as a special insight into how unions work. And Tricia Moore was a longtime investigator with the National Labor Relations Board. Each of them brings something unique to the table. And welcome once again, all. We're going to begin this part 2 of our discussion with Terry Potter, who's commenting on how the National Labor Relations Board's new look at remedies is going to affect so much of our employers' review of their own activities at the workplace. Terry, take it away.
Yes. Well, the bottom line is this. The region is acting as counsel for the general counsel in the prosecution of these cases, and therefore is under the direction of the general counsel and must follow her memos and guidelines. The administrative law judge is not under the GC, and therefore there's not a duty to the ALJ to follow those memos. And in fact, on a number of these remedies, I've got the ALJs involved early on and settled cases where some of these I find more outrageous remedial provisions are found by the judge to be improper, and I've gotten unilateral settlements, I've gotten bilateral settlements, and it excludes some, not all, but some of these more maddening remedies, such as sending apology letters out. I've gotten that eliminated in particular. I mean, that's not what the NLRB or the government should be doing. And indeed, the Court of Appeals have agreed with that too. So I think he can still do that, get the ALJ involved early. And if you want to settle the case, and it will make your life a lot easier.
Well, that's helpful. And it's good advice. It goes along with Tricia's statement that you really do need folks who've been around the block on this a few times. Dilettantes in this area, they oftentimes are surprisingly excellent, but there's just some nuances that it's really hard to own. By the way, Tricia, you mentioned the Cemex case, and the case that basically says if you're engaged, and I'll abbreviate it, if you're engaged in an unfair labor practice during the course of an election campaign, that may be enough to impose a bargaining order on you. And that used to be a very, very, very unusual order saying that, no, we want the employees to have a right to vote on this. We don't want to impose a union relationship. But that imposition is much more likely given that Cemex case. So tell us what's really going on post-Cemex. And any of you can jump in first if you want in terms of this imposition of remedy, if you will, for a ULP that's not just, whether it's draconian or otherwise, that's sort of make whole remedies, but it really is related to a union participating on behalf of all of the employees, even those who would not have chosen to vote for a union in the first place. Who'd like to kick off with that sort of discussion on that newish remedy?
Yeah. Tricia, I'm so glad. Yeah, you segued really nicely into Cemex, which is a remedies case. So in Cemex, there was an election where the union lost and ULPs were filed. And essentially, the board found that those ULPs were so bad that it was and influenced the election process to such an extent that a fair election wasn't possible. So the board ordered bargaining, meaning union lost, but that no matter, union wins. And the union is the bargaining representative for that particular unit of employees. And the employer is obligated to bargain with that union. So that was the remedy issued in that case. The board, went further to say that we're going to overrule 50-year precedent that said that, an employer had the right to insist on an election. It could refuse an employee's demonstration of majority status. They could say, hey, we want an election. No matter you're showing us these signatures, you're showing us these cards. We are refusing to accept that evidence. We want an election. And that's not a ULP. The board said we're overruling that case and we have a new framework to announce. And essentially, it is the new remedy for when an employer is presented with the union cards. The representatives of the union, the employees say, here, employer, here is our evidence of union support, whether it's, a petition signed by 30% of the employees, a union cards. The employer can either say, okay, great, we want to recognize you. The employer can file its own petition for an NLRB election, but they got a very short window of time to do that. The clock is ticking. You got a 2-week, right, window. And this could be a situation where you have a hapless first-line supervisor who gets those union cards for that petition and has no idea what it is, doesn't know the first thing about, never saw a union card, right?
So there can be a remedy for failure to react quickly enough. And in my world, that could be a double whammy because joint employer status has also been amped up under this board and this general counsel. So there could be two different, what we would think of as employers for employees who are temporarily engaged, supplemental staff and so forth. And suddenly a company that really just assigns people to another workplace, they might have a union as well. And they might never have seen the petition, or at least they're going to argue that they should have seen it beforehand. But right now, both of those employers might have a single union representing all of the employees working at Acme Steel or whatever it might be, right?
Yeah. Oh, I'm so glad you brought up that scenario because that's not unheard of, right? I mean, it's not. Employer provides employees, their employees on, work on off-site at another facility, some other place. And those employees, they have presented to the supervisor, that again is the employer's supervisor, that they want to be represented by this union. And also, maybe that union that's organizing these employees thinks that the on-site vendor is also an employer, and you have two bargaining orders. You have employer is being called to the table to be forced to bargain because they didn't know what was happening off-site. And also suddenly you're in this relationship, this joint employer relationship, and both of you are required to be at the table bargaining with this bargaining unit that you didn't even know existed.
And unfortunately, even with sophisticated organizations that have 50 or 20 offices around the country, if they haven't trained people to be ready to accept or not accept this, it was just the other day that one of our clients came and said, And we didn't even know this. This happened to be an EEOC petition or charge that came in, and they hadn't reacted to it. We were able to, go and convince the EEOC to help to allow us to put in a position statement anyhow. But in the board case, they would have just had a union.
Yeah, I cannot stress the importance to listeners, clients, non-clients. If employees are complaining, even if you are not hearing the word union, if employees have complaints, listen to them. If you even have an itch that employees may be interested in third-party representation, please call your labor attorney. Because I always tell clients, labor law is not intuitive, and actually throw your intuition out the window because it's probably going to be about 99% wrong. And what you think is the right thing to do or say really isn't. And the only reason we know is because we've been doing this for decades. But it's not employment law. This is labor law, and it's different. And it is worth the investment to have us come in and coach and train and teach about the law so you are not faced with labor board charges. And if you are, then we are able to zealously defend those and, get you the best quote unquote remedy possible.
Well, in a sense, we've talked about procedural remedies. That is, you didn't go and file your own petition when somebody came in with cards or whatever kind of piece. There's the other part too, which is that a pretty common variety of a ULP, the kind that would never have resulted in a bargaining order, as Megan suggested, now results in a bargaining order, even if you did engage in the whole election process. And that's quite a change, isn't it, Terry?
Yeah, it really is. I mean, this whole area that's developed in the last year, really since last August. I mean, it's really been a quick turnaround with this new approach regarding bargaining orders, and it's way beyond anything we've ever experienced in the past. I mean, the worst case scenario in the past was having a non-majority bargaining order, which most of the courts turned away from and didn't enforce. Now we have something that's much worse. It's if there's a singular unfair labor practice, at least in theory, that could result in the employer having a bargaining obligation with a group of employees with minimal effort and probably little interest among the employees. I know I was involved in a recent organizing campaign where ultimately that was the outcome. I mean, the employees had the bulk of them. We had an election. We never got the results because we had objections filed and challenges. There were ULPs filed. And as part of remedy, it was a bargaining order. And finally, the client said, I'm not going to spend any more money on a bargaining unit of 12 employees. I'm just going to recognize the union and move forward, and let the employees deal with this.
That's tough stuff. That's expensive stuff, potentially, too. Trish?
I think Terry brings up a really good point that it's difficult for small mom and pop shops to see going into this. You talk to employees asking them questions about improving working conditions, and little do you know, they're talking about a union and you had no idea. And then all of a sudden you have multiple ULPs. One of them is terminated because he's a no-call, no-show for a week. The union files a charge alleging he was terminated for his union activities. And the only way you may be able to prevail is, as we've seen recently in Thryv, is you're going to the Fifth Circuit to try to get relief, or whatever circuit it is that you're in. And most clients, not all, but a lot of clients do not have the resources for something like this. And so then they end up with these consequential damages and remedies that are still very far-fetched because they're not in a financial position to fight.
Well, and the board reported in April, for instance, that during the first 6 months of fiscal year 24, which was October to March, that's why it's reported in April, union filings for elections were up 35%. This is not going unnoticed by those who would seek to represent employees. Obviously, ULPs are up by, I think, 10% during that same time period. So the folks who are out there recognize that there's an easier place to come. By the way, what happens when you have this imposition of a bargaining order and you say, no, instead of the 12-person shop Terry that says, I don't want to spend another 50K finding out whether I'm right or wrong. Is there a way, and what is that way for the employer to say, wait a minute, I'm going to go get relief from maybe the court system? Is that really your last best hope for the expense and the time and the energy you're going to put in? And as we know, the potential for remedies for people who are laid off or otherwise affected during that time to be mounting up. But what can employers do? What are their remedies these days? I'll let you, Terry, take first swing at that.
They are in a big pickle, to use a legal term.
That is a legal term.
It's, you just don't have much in the current environment to fall back on as a small employer in these circumstances. There's no quick route to get to the court system to hopefully overturn this. Because if it's a bargaining order, you can't modify anything while you're taking the matter up on appeal. You may very well have unlawful discharge obligations that you have to deal with. And if you've got back pay accruing and maybe other so-called non-consequential damages, then, the numbers add up quickly. Plus, you got to pay an attorney to defend you.
Isn't that a good thing? Wait a minute. No, I appreciate that. And we really do try to minimize that and work with clients to say, what's the risk-benefit analysis here? But unfortunately, sometimes if you're going to resist this, you do have to go all the way up to the courts, and that is not a cheap process.
No, it is not. But, ultimately it becomes, like everything else, a business decision as to where you want to spend your money.
Well, it's so redundant as we come to the end of these doom and gloom podcasts. Some of them are, unfortunately, that we end up in the same place. And we've already sort of anticipated that it's not that you're just going to fight till the last bullet is out of the gun. You're going to go all the way to the court, the Court of Appeals, the Supreme Court. If you have $1 million, you can. If you have a bargaining unit of 10,000, like you have at BMW or Volkswagen in the South or something, you might be able and willing to do that. That's not most of us. That's not most of our clients. So the trick is, right, I think Tricia already suggested it, make sure that your relationship with your employees makes the idea of a union redundant. And certainly, if you get an inkling that there's a little bit of a rumbling at one of the locations of your employees or at the headquarters, what have you, start taking a look and say, why is that? Do we have some supervisors who frankly just aren't meeting our standards and they're being arbitrary or capricious? Or do we have some policies and some handbook items that really don't meet the competition anymore? We're not as flexible with our time off and so forth, looking at the marketplace. But a lot of that calls for an awareness and some of it calls for training. So what kind of training have you seen some of our clients, our friends ask for that Husch Blackwell or others like us might be able to offer to either make unions redundant or to respond if unions are starting to march towards employers? And why don't we'll let Trish start off with that one.
Sure. We are able to provide any type of training you are interested in. I mean, our bench is that deep and that broad, but many times we'll come in and we'll assess, is there vulnerability in your facility? Where is that vulnerability? What is causing the vulnerability? And then based on that, without giving legal advice, we will develop a program to engage employees, improve manager performance, not just employee performance, but increasing and improving manager performance, because many times a union problem is a manager problem.
Yeah.
Not always, but many times it is. And so we will hold our clients' hands to ensure that throughout that process, they are not breaking the law, that they are providing legal, truthful, factual information, and that the managers are not crossing the line to engage in unlawful behavior.
Yeah, oftentimes that investment is far less than either fighting ULPs or getting involved in union elections, which can be an expensive process and take an awful lot of focus and time away from managers and executives who spend their time better trying to help their customers, their clients, provide the services that they do.
Yeah, when I work with clients on campaigns, they usually say, "Oh, we like you so much and we've learned so much, but we hope we never see you again." Because it is a time suck. But also, as all of us attorneys know, going to trial is a time suck as well. I mean, for clients, that is what they're focusing on 100% of the time.
So, Megan, as you think about, the remedies being amped up, the opportunities for obviously elections growing as well as ULPs growing, what kind of advice have you seen fruitful for clients, or when you were in-house, what kind of things did you look at? Because you practiced in-house for quite a while too.
Certainly when the Thryv decision came down, executives and managers that were not necessarily, interested in NLRA issues, ears started to perk up. And then with the CEMEX decision, I sort of just explained in kind of basic terms what that meant. It was immediately, every single first line supervisor on up needs training yesterday. We did it immediately. I saw immediately the switch flip in leadership. They understood the enormous impact that case could have on any of their work sites, and they jumped into action immediately. And I don't think that was an overreaction. I think it was a complete, appropriate, correct response. At minimum, to make sure every supervisor knows what a union card is, knows what a petition is, knows what to do if an employee comes to you and mentions anything about, here's some sort of evidence that we want to be represented by a union. At minimum, that's at minimum. And then that starts the conversation with your managers. Oh, well, what is a union? And what does that mean for me? And how does that impact my job? And we had very, very fruitful and good, productive conversations and trainings that started with that, that case, which I think, is just that impactful and that important.
Terry, thinking that the suggestions from Tricia and Megan are right on, but any sort of thoughts you'd like to leave with our friends in our audience about how to prepare for this brave new world under the leadership of GC Abruzzo?
Well, I think Tricia hit the nail on the head. It's preparation, advanced planning, training. That's basic HR, folks. HR 101 is training, 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 whether it be on harassment or anything of that nature, wage and hour, or union avoidance. You can't stick your head in the ground regarding any major issue. And right now, one of the major issues that can get you in big trouble for a long, long time is having a union come into your facility. Don't ignore it. Prepare for it. Preventive medicine works. You just need to make sure you take those first steps.
Well, some of my training over the years has started and ended with the word respect. RESPECT is a great song too, but if you respect your employees and you train your supervisors to see these are human beings who are under pressures, who are trying to do the right thing most of the time, and sometimes they're not, and they're then a cancer, and it's time to relieve them of their opportunity to be a cancer in your place. But respecting your workforce is a huge, huge part of this, and you can't just pretend it. It's either there or it's not. So I'm hoping that most of our clients already know that. In fact, we know that because we've worked with some of the best clients in the country. But as you move through this, I hope that these bits of advice, this little bit of a change, or maybe it's a sea change in the way in which the board is recognizing employer and employee actions, has helped you. So thank you so much for joining these fantastic labor law insiders. Thank you, Megan, Tricia. Thank you so much, Terry.
Thank you.
Thanks, Tom.
See you soon.
All right. Take care and join us next time for the Labor Law Insider.